So
Okay.
Sue, you're
Yep.
recognized.
Thank you, Ken. This is Sue Melendy. I am with Justice for All Florida Incorporated. I'm also a daughter, a healthcare surrogate, a trustee, and had DPOA of my mother that was blind for 5 years, and now my 93-year-old father, which we get dragged back into court again today and get to spend the afternoon at the DMV because of a sibling that lives in Massachusetts that never had any interest in the care of either of my parents. And unlike some of the statements today, and similar to Doug's story and many other stories, my parents had advance directives. My parents had an estate plan. My father was a firefighter EMT for 31 years and went out on a disability because he's illegally deaf. Yet the courts have denied my father ADA accommodations. So when you talk about us needing laws and statutes, we have federal laws. We have laws and statutes within the state of Florida, but I can promise you, in probate court, they are not adhered to. They are not followed to. We have a case in the second DCA where we have to argue and pay money and expense and take time off of work to argue a statute that says an alleged incapacitated person may substitute their attorney. And that happens every single day in court when it's the people that litigate and do this for a living to make money. But when it's somebody that comes in to represent a poor soul like my father that worked his whole life for his own retirement and his own savings, he was told, no, you cannot have the attorney that you choose to have, even though we all know it's the AIP and potentially the ward whose money pays for these attorneys, that pay for the guardians, that pay for the ETGs, that pay for the committee members. And if your money is going toward hiring a person, you should get a say as to who that person would be. And no, you don't get to stipulate on behalf of a person the day that they go to court for these emergency hearings, when in fact, there's no emergency. We were months into the hearing that we never even needed an emergency guardian, and it got extended and extended and extended, which is also not Florida statute. So we are the poster children for what it looks like to have a loving family, advance directives, and then we can argue semantics that just because somebody doesn't like another person, just because somebody wants to make false accusations, that we can put somebody into guardianship, keep them into guardianship, and then turn around after a year and a half, say that the person now requires a plenary guardianship. It is shameful, and it needs to stop. And you're ruining these elderly people's lives, let alone their family. Thank you very much. I appreciate the opportunity.